Great, thanks. So good afternoon, everyone. I'm Mayor Schulman with the Hartford Foundation's Nonprofit Support Program, and I want to welcome you all to today's session on legal issues related to returning to the office. We recognize that when we planned this session several weeks ago, we were in a very different place regarding the COVID situation and the Delta variant. So we realized that the timing of your plans to return to the office may have changed since you signed up for this session. I did want to mention that while there are some legal questions around returning to the office that are very important, many of the issues related to this topic are not legal in nature and really relate to the specific needs and considerations of your individual organizations. And so this is where connecting with each other outside of this session to share resources and learn from each other could be very helpful to you, and we really encourage you to do that. Those of you who run Zoom workshops yourselves know that they are a team sport. So special thanks as always to my NSP colleagues, Betsy Johnson and Monica Kelly, for all of their behind the scenes assistance and great teamwork in planning for and managing today's session. This question always comes up, so I will say that we will be sharing the session recording as well as the slides with all of you and anyone who registered for the session following today's session. Also, Betsy will be posting the survey for the session in the chat towards the end, and she will also be emailing you the survey immediately following the session. It's the only price of admission, the survey, and really value your feedback and take your comments to heart. So please do take a few minutes and fill it out. So we're offering today's workshop in partnership with the Pro Bono Partnership, which is a nonprofit organization that offers free non-litigation legal services to nonprofits. I'd like to thank Priya Morgenstern and Robin Schwartz of the Pro Bono Partnership for their collaboration in bringing this workshop to all of you today. Priya can't be with us. She's on a well-deserved vacation, but Robin is here, and I want to thank her for stepping up and being part of today's session. Robin will be performing the all-important task of reviewing the questions that all of you submit in the Q&A box and feeding your questions to our presenter at the end of his presentation. So please remember to put your questions in the Q&A and not the chat at the bottom of your screen, but feel free to use the chat to share any thoughts, comments, resources that you think may be helpful to your fellow participants. So just to review, questions go in the Q&A, and thoughts, comments, and resources can go into the chat. If we aren't able to get to all of your questions during the session, our presenter has generously agreed to stick around for about 15 minutes following the session to take additional questions. So now I'll turn the program over to Robin, who will introduce our presenter for today, attorney Matt McClave, who I want to thank profusely for generously donating his time to present this session for us today. So it's all yours, Robin.
Thanks, Mayor. I am Robin Schwartz. I'm a senior staff attorney with the Pro Bono Partnership in the Hartford office. I believe that most of you are familiar with the partnership, but for those of you who are not, we are also a nonprofit 501c3 public charity with a mission to provide pro bono legal services to nonprofits serving Connecticut, New York, and New Jersey. For more information on our programs, I do invite you to look at our website, which is www.probonopartnership.org. And now I'd like to introduce our guest presenter, who is attorney Matt McClave. Matt is the owner of the law office of Matthew T. McClave, PLLC. He has been a labor, employment, and civil rights attorney for the past 37 years, and he represents the interests of both individuals and businesses. Very importantly, he is also a wonderful, very dedicated volunteer with the partnership. In fact, he is a 2020 Volunteer of the Year Award recipient for his pandemic response work. And with that, I'm going to turn things over to Matt.
Thank you very much, Robin and Mayor. Thank you very much for the opportunity to speak with you today. I'd like to thank the Pro Bono Partnership and the Hartford Foundation for Public Giving for this opportunity and for setting this up. And thank you for joining us today. So my name is Matt McClave. I'm an attorney. I've been in this space for over 3 decades. And I will admit that last year has been one of the more challenging periods of my practice. Where the rules seem to change on a daily basis. So with that, let's start with the presentation. Of course, there are always some disclaimers. In this presentation, I'm giving general information of interest to the public. I'm not providing legal advice. Audience members should not take action based upon what you hear today, but after conferring with legal counsel. There are lots of very complicated issues, and this changes very quickly. Remember that this presentation, the Q&A, the chat feature is not protected by the attorney-client privilege. Please don't share confidential or non-public information. If you're gonna hit a bank this afternoon and take out a large sum of money, don't put it in the chat or the Q&A. We don't wanna know that kind of thing. And it will be recorded, so it'll be around. All right. One other disclaimer is this is a rapidly evolving situation. I don't recall a time where things have changed literally by the hour in this field. So you have to be careful with that. And I'm actually willing to bet you dollars to donuts this presentation is outdated before we even start. All right. Here's the agenda. These are going to be some of the things I'm going to try to cover today. Why it matters, why returning to the office in an organized manner matters, the current legal restrictions. I'm going to be talking about Connecticut and New York. I'm not admitted to practice law in New Jersey, so I don't purport to know New Jersey law, but I believe that you're going to get some useful information just by paying attention to what these other states are doing. We're going to talk a lot about vaccinations, masks, social distancing, and I also want to touch on some other legal issues that you should probably be aware of. All right, why does it matter? You need to be organized and you need to have a plan in order to return to the office or reopen to the public in order to have people come in. And why do you need to do that? Well, firstly, if you don't, there could be civil and criminal liability as a result of the way that you run your organization. You should really care about those safety rules. Your people should really care about those safety rules. Now, while there could be criminal liability, that's in rare circumstances, but fines and penalties are not rare. They are actually very common. Most of the rules regarding COVID are implemented pursuant to public health orders, and mostly they're fines as a result of the public health emergency. You could actually lose your business license to conduct any business whatsoever. So you have to be careful about that. There are also civil liability. Now, in general, civil liability will come through lawsuits or other claims, what we call common law torts. The most common one is a negligence claim. In order to prove a negligence claim, there has to be some kind of duty that you owe the public or other individuals, that you've breached the duty in some way. There's causation and there's damage. There are going to be huge litigation issues around these things. What is the standard of care? If it's a regular negligence claim, then the standard of care is what does a reasonable person owe the members of the public or your employees. One exception is if you are inviting people into your premises, if you're conducting public spaces, if you're conducting a concert, for example, or you're running a museum, you're having invitees come into your premises, you actually owe them a higher duty of care than you would otherwise owe them. There you have to disclose known, non-obvious dangers. So if you have had a COVID outbreak, you may have an affirmative obligation to advise people, members of the public, that there's been an exposure. Most of your employees are going to be covered by workers' compensation. These other claims are going to be covered by insurance if you have it. There are pandemic exclusions in some insurance policies, so you really have to check your insurance policy before you open your doors to the public to make sure you know what's covered and what's not covered. A couple of other things I want to mention too. Remember as well that there's a very big public relations component to anything you do. Whenever you're interacting with the public, you have to keep in mind what your brand reputation is going to be affected by how you do things. We're going to talk a lot about masking and about social distancing and about vaccinations, but think about how those messages communicate to the public and how they impact your brand, your reputation. Think about how they also impact your human resources policies and practices, not just what you do, but how your employees feel about the organization and how they interact with the organization as well. These are all very, very complicated topics, and you need to be thinking about them objectively when you're going through the process. All right, let's talk about current legal restrictions in Connecticut. The basic backdrop is the public health order that was put into effect on May 19th of 2021. This is Governor Lamont's executive order that authorized the public health order to come into effect. It's all subject to the requirements of the governor's executive order. That's still in place today. And so basically, anyone who cannot safely socially distance at least 6 feet and who have not been vaccinated, you must wear a mask. So anyone who is not vaccinated has to wear a mask in the state of Connecticut if you can't keep 6 feet away from somebody else. Regardless of your vaccination status, masks must be worn in a public or private school, in a child care facility, including youth camps, in a healthcare facility, in a homeless or temporary housing shelters, and in correction facilities or mass transit. So Metro North, you got to wear a mask. On a bus, you got to wear a mask, regardless of your vaccination status. And that order still remains in effect. We have an interesting, and on August 5th, Governor Lamont refused to issue a statewide mask mandate because of the coronavirus Delta variant. He did not issue a statewide mandate, but he adopted an executive order that allows local mandates. Now, the way this works is the local mandate has to comply with the executive order. And the executive order says, first of all, those other places that we just had on the previous slide, you have to wear a mask regardless of vaccination status in those places, except if doing so would be contrary to your own health or safety due to a medical or behavioral condition or a disability, or if you're younger than the age of 2. So that's important. This isn't just a medical disability issue, it's also a behavioral issue. If you have a behavioral issue that prevents you from wearing a mask, even if you're not vaccinated, the governor's executive order exempts you from that requirement. Now, the local mandates, local municipalities can adopt a mask mandate, but they can't be inconsistent with the executive order. So on the hierarchy, it's the executive order is here, the local mask mandates supplement it, they can't contradict it. Businesses are allowed to require everyone to wear a mask, however. That's the governor's executive order. So you as a business owner have the right to demand that everyone, regardless of vaccination status, get to wear a mask. Recognize that in contrast to vaccinations, which we'll talk about in a bit, there is no exemption from the mask mandate because of a sincerely held religious belief. And that there's some technical, complicated employment reasons for that, but there is no religious exemption from the mask mandate. All right, next. As of, literally I just checked this about an hour ago, as of now, Bridgeport, Danbury, Hartford, Stamford, and Norwalk all have mask mandates. That means any person, regardless of vaccination status, has to wear a mask in a public setting. In addition, on Friday, New Fairfield, Bethel, Reading, and Ridgefield also adopted that requirement. Those are all communities around Danbury. There are many other locations, municipalities that have mandates for their public buildings, but these mandates are citywide or municipality-wide mandates. And so if you're operating in one of those jurisdictions, for the present time, you have to have all of your folks wearing masks, all of your invitees, et cetera, et cetera. All right. On August 6th, the governor issued a mandatory vaccination requirement for certain employees. It is effective immediately, but you have to comply by September 7th. So there's a bit of a grace period here. It applies to nursing homes, residential care homes, assisted living service agencies, and intermediate care facilities for persons with developmental disabilities. Now, what this means is in order for you to allow these individuals to have direct patient contact, they either have to be fully vaccinated or they've received the first dose and the second dose is scheduled to be given, they are exempt because a physician assistant, or an advanced practice nurse determines that getting vaccinated will be detrimental to the person's health. So pay special note, these are very specific designations. It's a physician, a physician's assistant, or advanced practice nurse. It's not any healthcare provider. So it's only those individuals. And finally, because you're exempt because of a sincerely held religious belief. I've just mentioned this before with respect to that. There's no religious exemption for the mask mandate, but there is a religious exemption for the vaccination mandate. Watch this space. I believe this is very interesting. When we talk about vaccinations, you're going to see there are different ways the vaccination mandates, the ones we have, are being implemented. I believe we're going to see this tension evolve between this. There is no alternative for these employees other than vaccinations. So there's no testing exemption. There's no other exemption. It's just a mandatory vaccination mandatory vaccination. All right. Current legal restrictions in New York. New York has adopted the CDC guidance as of May 19th. That hasn't changed. If you're unvaccinated, you must socially distance and you must wear masks when you're in public. If you're vaccinated, social distancing and mask wearing are not required. If you do not know whether the person is vaccinated or not vaccinated, you need to treat them as if they're unvaccinated. New York has this Excelsior Pass system. So the Excelsior Pass can be accepted as proof of vaccination status, or they allow self-reporting in many circumstances. Self-reporting basically is the honor system. If someone declares themselves to have been vaccinated, that's a good standard for New York State. These are New York State guidance. Again, businesses can require individuals to wear masks. Interestingly, one of the variances in New York State, businesses are allowed to adopt vaccinated only spaces. So if you are a restaurant, for example, you can have a vaccinated section and an unvaccinated section. If you are having a vaccinated section, you cannot rely upon self-reporting. You must police the vaccinated section with having either proof of the Excelsior Pass or some other proof of vaccination status. So think about that as an alternative. Children under the age of 16 may enter that vaccinated area, even if they're not vaccinated, as long as they're accompanied by a parent or a guardian. So that may be something we start to see in New York State as an incentive for people to get vaccinated. Maybe they go to a better place in the restaurant with other people that are, quote, safe. Maybe that is some system for performance centers. Maybe the balcony is reserved for vaccinated people and everyone else is in downstairs. Again, there's going to be a policing issue with respect to that, et cetera. In New York State, there is still a limit on the number of people that you can have at events. If it's an indoor event, you cannot have more than 250 individuals. If it's an outdoor event, you can't have more than 500 individuals. What does that mean? If you're below the limit, if you're below that 250 indoors or 500 outdoors, you're allowed to rely on self-reporting for mask wearing. So if you're below the limit and someone declares themselves to be vaccinated, whether they're being honest about it or not, you can say you don't have to wear a mask. If you have more than 250 people indoors or more than 500 outdoors, you may not rely upon the honor system. You may not rely on self-reporting. The law requires you to have some kind of proof of vaccination before you allow people not to wear masks. All unvaccinated people must wear masks and must have social distancing. So that if you have limited space available in your facility for whatever you're doing, you need to think about how you're going to enforce that and what the limits are going to be. All right. New York City on August 3rd, New York City announced it will require proof of vaccination for indoor dining, performances, and gym attendance effective today. Enforcement will start on the 13th of September. It is not an indoor mask requirement, however. It's a vaccination requirement. We have no word on exemptions. Remember, I talked about exemptions for medical reasons or exemptions for sincerely held religious beliefs. There's no word on exemptions yet. I checked the City of New York's website. I understand Mayor de Blasio made some remarks this morning about this, but I haven't had a chance to take a look at them. So this is going to be evolving. If your head hurts, I share your pain. This is a constant challenge for all of us. I want you to pay attention to what happened in California last week. California announced, it's the first state to announce, all teachers must have proof of vaccination for the fall, or they have to submit to weekly testing. Now, I mentioned before there's this dichotomy. In Connecticut, there is no exemption for vaccination for those healthcare workers that are covered. There's no weekly testing requirement or masking requirement. It's just vaccination or you're out. In California, it appears that they have adopted this other alternative. If you don't get vaccinated, you have to submit to weekly testing. I suspect, here's my prediction, I suspect that is going to become the prevalent view. So I think, and that's a little tidal wave, I think California kind of changed everything. Once California went there, coupled with New York's mass vaccination mandate, I think we're going to start seeing a lot more businesses and a lot more municipalities and cities and states across the country start to adopt mandates along the vaccination lines. Candidly, that doesn't please me. I'm not a vaccination mandate kind of guy, but that's just my personal and political opinion. Everything else is up to you guys. But I will tell you, the other prediction I have is if you have mandates for vaccination, there are a bunch of people that are just going to go nuts. There's no question in my mind. I think 200 people showed up yesterday at de Blasio's home, Gracie Mansion in New York, to protest the vaccine mandate. And we're going to see more of that. I think it's very controversial. All right, let's talk a little bit more about vaccinations. For employees, can you as an employer mandate that your employees be vaccinated? Well, the EEOC says you can, so long as you have an exemption for people that have a medical issue or people that have a sincerely held religious belief. And that's because federal EEO laws give you a duty to accommodate religious beliefs and disability status people who have medical conditions. So the EEOC clearly believes you can do that. At least two courts, a Texas court and the Seventh Circuit Court of Appeals, have agreed with the EEOC and dismissed claims challenging the vaccination mandates. And at least one Supreme Court justice, Amy Coney Barrett, who denied an appeal from the Seventh Circuit, she's from Notre Dame, as so am I, so there's an affinity there. She agreed with everybody. I think there's a strong case that can be made that vaccine mandates are not consistent with the United States law, but I've been shut out all the time since then, so I'm kind of resigned myself to giving up the ghost. If you are going to require vaccination mandates for employees or for your employees, remember that information may be protected health information under the ADA, and you may have to think about how you're going to safeguard it. Now, I will tell you that the EEOC recently put out guidance that said your vaccination status is not protected health information. I don't understand how they reached that conclusion. I think they're dead wrong based on the literal language of the statute. But again, I'm not on the Supreme Court, so what do I know? And then you're going to have to think about whether you rely on an honor system along those lines for your employees. Do you just take their word for it? How do you prove a sincerely held religious belief? How do you prove that they are vaccinated? What kind of things can you get? There are now a lot of fake vaccination cards that are circulating around. I've heard this through anecdotal means. So that's kind of a challenge for you. Then you need to think about what you're going to do if you're going to require vaccinations. What are you going to do for your volunteers, your board members? If your employees are going to be vaccinated, do the board of directors get to escape that requirement as well? What do you do about patrons or guests or people coming to visit your premises? How are you going to deal with that? I think there's a big public relations issue here, particularly because not everyone can get vaccinated. Many people are immune compromised and will not be able to get the vaccinations. And currently, anyone under the age of 12 is not allowed to be vaccinated yet either. So that becomes a little bit of a challenge. Do you want to think about a vaccinated only section or a vaccinated only performances or something else along those lines? One other thing I want to mention about the employee issues, I have heard anecdotally that many employees who do not want to get vaccinated are leaving employment because of vaccination mandates. I've heard that in several cases already where people either refuse the job offers or resign their employment because work is so easy to get right now that they're just going someplace else. So think that, and I mentioned before, that's that HR issue. If you're going to have a vaccine mandate, what's going to happen when your employees start to resign, particularly if you have a staff shortage, if you're in one of those industries where you've always had chronic issues, think about how you're going to be handling that. Vaccinations as well. If you're going to require vaccinations, I want everyone to keep in mind that vaccines are not 100% effective. Now, this vaccine turns out to be very, very effective. There are several different kinds. Their efficacy is slightly debated and maybe slightly, but it's in the 90 percentile. I mean, that's incredibly good. That's the original COVID and the Delta variant. You're going to start to hear about the Lambda variant. If you haven't already, that's another variant that's coming around. And I call the next one new COVID or new Coke. I mean, it's going to happen. We're also hearing anecdotally about health issues affected on those breakthrough cases for people that if they are vaccinated, what happens to them. There was a story in the New York Times today about vaccinated people who come down with COVID-19 may have some of the same symptoms and long-term effects of those long haulers, those long COVID haulers that we heard about earlier on. There are also different stories about side effects and effectiveness. I'm not even going to get into that. I'm not a conspiracy theorist, but I think we need to be wary of that. So just because an employee is vaccinated doesn't mean they can't get it. It doesn't mean they can't transmit it. It doesn't mean they can't die from it. The likelihood is they will not be seriously ill, but there are exceptions to every rule. And in keeping with that, we believe, and we've heard anecdotal stories about this, at the very least, that some people that are vaccinated will contract COVID and will unfortunately pass from COVID-19 or some variant of COVID-19. And I think that's likely almost inevitable. Masks. Every order that I have seen, public health order, has allowed businesses to adopt mask mandates that are more inclusive than what the local municipality is. So in Connecticut, for example, I mentioned that Connecticut and New York both made very clear that a local business can adopt a mask mandate universal use. If you're going to have a mask mandate, or if you're going to have any kind of vaccination mandate, you have to think about what you're going to do with objectors. And they come in three different categories. Employees who are objectors, you need to have a process to identify them. How are they going to prove their objection status? What are you going to do about that? There are a whole host of issues we'll talk about in a minute. What are you going to do with your guests, your patrons, the people that give you money for the service, or the people that you are performing services for? How are you going to deal with them if they object to masks or vaccines, quite frankly? And then finally, what about the other people that come into your premises? They are the delivery drivers. They're the mail people. They are dropping off equipment. They're fixing your refrigerator. They're performing maintenance functions. They are invitees into your establishment. What are you going to require of them? These are very complicated issues. particularly if you're dealing with an invitee, a maintenance crew, someone that's coming in to provide a service for you. How are you going to deal with their employer? How are you going to deal with their business? So there's a very complicated issue here. We've been wrestling with these issues from the beginning of the pandemic. I do represent real estate clients that develop and lease real estate, and we've had tenant issues and things that have been very challenging for us. And so we've had to go through and have a very candidly robust discussion about what the right thing to do is for the industry and for the tenant and for their employees. And it is not at all easy. I don't believe there's any right or wrong answer to this. It's just very complicated. Okay. Social distancing, the 6 feet apart rule creates all kinds of capacity limitations. You may have 500 seats in your physical space, but you need to think about how you're going to fill those seats. How are you going to determine what 6 feet apart is? And that's what, again, I mentioned this vaccinated section versus the unvaccinated section. That may be something for some individuals, some organizations that will be good for them. That will be a way to deal with the situation. And then you have to determine how are you going to prove whether someone's vaccinated or not. What kind of records are you going to try to keep? Let me talk about some other issues, if I can advance this slide here. There we go. Let's talk about some other issues. OSHA came out with guidance on June 10th regarding their recommendations for treating employees. Now, these are just OSHA recommendations. It's not an enforced requirement, but remember I said in the very beginning that negligence claims are based upon a duty, a breach, causation, and damage. I suspect that OSHA guidance will be looked at as creating a duty. So this may be the minimum standard of care that employers need to have in order to safeguard their workplace. OSHA recommends that paid time off be given to workers in order to allow them to get vaccinated or to get their booster shots, which we're going to start to see booster shots very soon, in my belief. That they give instructions for exposed workers to stay home and not come to work, that social distancing be required of unvaccinated workers, that you continue to do that stuff that we did before about limiting participation, limiting spaces, that masks would be required or more for unvaccinated workers. That would be, remember, the face shields, the double masking, the N95 masking, all that stuff that we did last year. We need to start thinking about that for our unvaccinated employees. Suggesting that unvaccinated employees wear face masks. I think that's a double. Okay. And finally, record keeping. Keep in mind that there are record keeping requirements under OSHA. If you have a worker that's been exposed to COVID in the workplace, or they come down with COVID, that may be a recordable event. It may be a reportable event. Recordable means it has to be written down in the OSHA log. Reportable means you actually have to call OSHA and tell them about it. And there's going to be very quick timelines. In the case of serious injury or death, I believe it is within 8 hours that OSHA has to be notified. Remember as well that Connecticut has adopted the Paid and Family and Medical Leave Act. This is a whole new series of requirements for paid leave in Connecticut, effective January 1 of 2022. Every employee in the state, regardless of the size of the employer, so if you only have one employee and that employee has been employed for 3 months or more, they're eligible for paid and unpaid family leave of up to 12 weeks plus 2, depending on circumstances. So potentially up to 14 weeks of paid or unpaid leave. That's job protected leave. For smaller employees, this is a huge change from the prior rules. If you've already been complying with the Family and Medical Leave Act, the federal FMLA, you're going to think this is the same. It is slightly different. It's slightly more broad. You're still going to have that coordination problem that you've had before. But for smaller employees, you have a mandate to adopt it, to have a new leave policy effective January 1, 2022. There are amended policies. I recommend you amend your policies and you update them by January 1st of 2022, because that's when the leave applications are going to be starting to come in. And so you may get a lot of that. Remember, if you're a New York employer, we have paid family leave. We've had that for a couple of years. We also now have paid and unpaid New York sick leave. So there is a New York sick leave policy in place. That's in effect now, and you've got to make sure that your policies are in compliance. All of those leave policies may be implicated by people that are exposed to COVID or have COVID symptoms, et cetera, et cetera. All right, this is a shameless attempt at self-promotion. One of the goals of my firm is to try to level the playing field by providing world-class services at affordable prices, particularly for individuals and smaller businesses. So we have several models. I would urge you to go to my firm's website, mcclavelaw.com. It's under transparent pricing. We have several models. One of the things we're doing, particularly for the Connecticut paid and family medical leave and the New York leave law, is we have fixed fee policy representation, limited representation agreements. We're able to get people help as much as possible. What I'm saying to you is, if you don't have legal services and you need something, reach out. We will work really hard to find a way to meet your needs. So we'll do that. What's the right way to proceed here? I think you have to decide, every business has to decide what's right for them. Think about all the things we've been doing over the last 15 months. Should you have screenings, temperature checks, and so on? Whether your employees are vaccinated or not. Are you going to have some exemptions for vaccinated workers where they don't have to do the questionnaires, the temperature checks, the screening, all of that stuff? Are you going to just require it of everybody? How are you going to police that? What are you going to do? There's no right answer. Well, I guess the courts will tell us what the right answer is in 5 years. But right now, it's all up to us to try to figure this out as we're going along. Vaccinations, are you going to require them for entry? That's a big challenge. You need to think about that. Along with the vaccination issue, you have to think about the anti-vaxxers. They all don't fit into one category. They're kind of in different places. Some people are not going to be able to be vaccinated because they're not of age. They're 12 or under. Some because they have a medical condition that prevents them from being vaccinated. And some because they have a religious objection, a sincerely held religious belief. And some people are not going to get vaccinated just because, in my view, they're kind of knuckleheads. And full disclosure, I got vaccinated the instant I could, and I'm really happy I did. But you're going to have a lot of dissenters. You need to think about how you're going to deal with that. If you're opening your doors to the public, if you're having folks come in, what are you going to do with the patrons of yours, the leaders of yours, the people getting services from you who are anti-vaxxers? For one of these reasons, they all don't fit in the same category. You need to think about how you're going to do that before it happens. Are you going to have testing alternatives to vaccinations? And again, both California and I think it's President Biden's executive order for the military has an exemption requirement that if you don't get vaccinated, you need to have periodic testing. You may need to wear masks. That seems to me to be an interesting way of approaching the alternatives. If you're going to have those testing alternatives, think about all the issues involved in that. Are you going to pay employees for the testing that they receive? Are you going to pay for the test? Right now, most of the tests should be free, but that may change. Which test are you going to require? The EEOC says a viral test is a good test. An antibody test is not an acceptable test, which means you can't require an antibody test. You need to think about the accuracy of tests. You're going to have false positives and false negatives. What are you going to do if there's a false positive or false negatives? What are you going to do for the employee? Is there who tests positive? Is there a work from home opportunity that you can make available for the employee or not? And then finally, what are we going to do about masking? All right. I know that this is a lot of stuff and it's hyper technical. And I know we went through it quickly. And that's because we want to try to get to as many questions as we can. So with that, I'm going to say thanks for being patient. Let the questions begin. I'm going to ask Robin to sort of screen them out. If we don't get to your question, or if you have any issues, here's my contact information. I encourage you to reach out, call, email, write. We'll try to find help for you the best we can as quickly as we can. Okay, Robin?
Thanks, Matt. I've got a lot of questions here for you, so we'll do our best to get through as many as we can. So one question here, do employers have to disclose to the public, invitees, or clients that unvaccinated employees are present on the premises?
Yeah, so that's a really good question. I don't want to give a yes or no answer. I think it is something to think about, that you need to think about. I do believe there is a problem with disclosing who is vaccinated and who is not vaccinated, because contrary to the EEOC, I believe that is protected health information, and disclosing someone's vaccination status where you can identify them is a problem. I think that also means letting vaccinated people not wear masks and unvaccinated people, you make them wear masks. That's kind of a signal. It's kind of a scarlet letter. So I'm a little uncomfortable with that. I think that if you take the position that the vaccines are not 100% effective, and even vaccinated people, even if they don't get COVID-19 illness, can still be COVID-19 carriers, I'm not sure disclosing that they have unvaccinated people as well really does a lot for you from a duty of care standpoint. I think it's a great question. I think it's a really hard question. And I've skillfully avoided answering it for you.
Thanks, Matt. Here's another question. Could you please explain what a behavioral concern is that would impact the compliance with the mask mandates?
Sure. So some individuals have emotional conditions. The best I could describe it as claustrophobia or fears of confined spaces. So wearing a face mask will cause an emotional reaction for those individuals. Such people usually, but not always, have other mental health issues associated with them. So if you are one of those individuals, you may have a behavioral condition that gives you an exemption from wearing a mask. And I think that's what the governor's order is thinking about.
Thanks, Matt. So here's another question for you. Actually, there were several versions of this question submitted. Which religions are incompatible with vaccination? And does it have to be a recognized religion? If so, how does the employer handle these types of claims? Yeah,
great question. So there are several religions that prohibit medical treatment of any kind that may come into play. But I think the second part of that question is better. I think it's a mistake to try to characterize a person's religious views, even if they're not orthodox. What the EEOC requires is the person have a sincerely held religious belief, regardless of whether it's a major religion or a minor religion or just their own religion. And as long as that person has a sincerely held religious belief, and it is sincerely held, and it is a religious belief that is for a greater being that is involved in our lives, then that is going to be protected, even if it's not one that we usually recognize. So we had lots of cases back in the 80s, because I've been practicing for a long time, about people that claimed to have a religious belief that required them to smoke marijuana on the weekend. That was, the question is whether that's a sincerely held religious belief or whether someone's faking it. You do get to contest whether the religious belief is sincerely held. You don't get to contest whether or not they have it. So as long as they're acting consistently with their religious belief, if they've refused all medical treatment, for example, or certain kinds of medical treatment. Additionally, there are lots of claims about the vaccine being developed in a way that violates people's religious principles of one kind or another, so that you may have that as well. So that's a really delicate area to tread on. I don't think you have to take someone's word at it. I do think you get to explore what their religious view is and whether it's sincerely held or not, and look to the totality of the circumstances to see whether they've been acting consistently with that. If they claim that the individual who's refusing the vaccine claims that they never accept medical treatment before, but you have a medical file filled with treatment records, then you may be able to legally question whether that's a sincerely held view or not.
Thanks, Matt. Here is another one for you. Is lying about your vaccination status to your employer grounds for termination?
Yeah, I think it may be. So the delicate area here, it may be, that's my short answer. The delicate area here is that generally an employee owes a duty of truthfulness to his or her employer, unless asking the question would otherwise not be lawful. And again, that's where we get into this whole, can you require employees to be vaccinated or not? And can you have alternative rules for the unvaccinated? I believe the majority of courts that have looked at the issue will come down and say lying to your boss about your vaccination status is likely cause for disciplinary action, up to and including potential discharge of employment. But again, you need to consult with an attorney on the individual circumstances each and every time.
Sounds great. We have a couple of questions now for you about reasonable accommodation. So if employers are going to be offering testing as a reasonable accommodation, who pays for that?
Yeah, so again, that's a great question. The reasonable accommodation analysis, and let's start first on the top end. We're going to talk about federal law. The Americans with Disabilities Act requires persons that have a disability to be reasonably accommodated, and you go through that through a process called the interactive process. The interactive process is basically a give and take. You have a dialogue about who's going to pay, when it's going to happen, how is it going to happen, who's going to be compensated. There are a host of issues around with that. One of the wage and hour issues is if you have a non-exempt worker and you're requiring them to get tested as an alternative, can you require them to do that on their own time, or do you have to pay them the time to be compensated? We don't have any guidance from the Department of Labor on that. Who's going to pay for the test? We don't have any guidance with respect to that. Now, right now, the tests should be free. Under all the orders I've looked at, testing has been free, but that likely will change as we go forward. The other issue is, do you have to pay for the transportation, right? That's the EEOC. That's federal law. It applies in all of the states. Individual states have different disability leave requirements. New York City, for example, has a very aggressive civil rights statute that applies for New York City employees. And there are few accommodation requests by an employee that will be unreasonable. So in those circumstances, an employee may be able to demand that you pay for the test and that you pay for their time in order to get the test. So that we're going to have to see how that works out. Again, if you have that situation, don't react without thought. Get legal advice to help you navigate those issues. It's a risk-reward analysis that you have to go through. How much risk versus what's the reward?
Thanks, Matt. We have a question here about a potential holdout employee among an office where everyone else is vaccinated. They want to know, is it legal to put pressure on that holdout employee to join everybody else and get vaccinated? And this is an employee who works with the public and makes home visits.
Yeah, the EEOC has taken the position that incentives are lawful, pressure is okay, urging people to get vaccinated is an acceptable thing to do. So as long as the incentives are not extraordinary, for example, as long as you're not giving out a new car to everybody who gets vaccinated, the EEOC says some amount of compensation, some amount of reward is acceptable. I've heard of situations where the CEO of an organization offered to go into a dunk tank, and you can, those tanks where you were over the water and you threw a ball to try to hit the bullseye, and if you hit it, they fell under the water. And only vaccinated people could participate in the attempt to get the CEO dunked. So There are lots of different things you can. Incentives are good. Education is important as part of this as well. A lot of folks have good reasons, I think, to be concerned about vaccination and mandatory vaccinations. Again, that's my personal opinion. So you need to have a dialogue. Oftentimes it's the dialogue that makes sense, but you need to take a look at your organization overall to make sure you're being consistent. If you're requiring your employees to get vaccinated, but not your board members, not your supervisors, not your patrons, is that sending the wrong message? So you are allowed to incentivize and encourage and pressure employees to get vaccinated. And everyone should, for the record, everybody should vaccinate. I think everybody should, but that's me.
Here's a related question, Matt. So about in terms of direct client contact, if an employee does have direct client contact, can you require the employee to disclose their vaccination status to the client so that the client can choose whether to accept or reject that visit?
So I am concerned about requiring employees to disclose medical information as a condition of employment. Again, the EEOC has said vaccination status is not protected health information. I think the EEOC is wrong, but I'm not a commissioner of the EEOC, so we'll have to figure that out. I would be concerned about the false sense of security if you are interacting with a member of the public and you say, "Oh, I'm vaccinated." Remember, vaccinated people can still carry the COVID-19 virus, and vaccinated people can still infect others. So if you have people interacting with the public, maybe the safer course of action is mask wearing regardless of vaccination status. That seems to me to be sort of touching all of the bases at the same time.
And I have a question for you within the context of child care facilities, but it may be broader than that. Can an employer refuse to pay an unvaccinated staffer who gets exposed to COVID and then needs to quarantine and therefore can't meet their hours?
So the question is, would that individual be entitled to paid leave under your policies or under state or federal law? There is no longer a federal law regarding COVID-19 exposures. That was the Family First Coronavirus Response Act. That leave expired on December 31st of 2020. So those were off the books. The Connecticut Paid and Family Medical Leave Act may provide for paid leave or unpaid leave as of January 1st of 2022. The current Connecticut Family and Medical Leave Act may provide for unpaid leave. The Federal Family Medical and Leave Act may provide for unpaid leave, and the employee may be able to use paid leave as part of it. So the long answer is you really have to go through all of these sources of law, and it's really a laundry list. What does your policy say about sick leave? What does your practice say about sick leave? What does the FMLA federal level say about it? What does state FMLA? You have state sick leave requirements in Connecticut and in New York that likely will provide some coverage under some circumstances for people that have been exposed. The easy answer was back in 2020. Those laws are no longer in place. Now it's the hard stuff.
All right, next question about independent contractors. How do you handle mandates with independent contractors? Specifically, this questioner was asking about schools or community centers, but does it change the game at all if they're an independent contractor versus an employee?
Yeah, it kind of does. Employees have more protections than independent contractors. However, I will say that many independent contractors are falsely classified as that. But if we're dealing with a true independent contractor, they are basically an invitee onto your premises. You owe them the same obligations you would owe anyone else, any other service provider coming onto your premises, or any other patron. And in those cases, you may be able to prevent entry for people that are not vaccinated or do not wear masks. You may be able to do that. So you'll need to think about, in each case, how do you handle those in aligned with other people? An independent contractor, a true independent contractor, will not have the exemptions that are allowed for employees. For example, that an employee, because of the status of the employee, is protected by Title VII, and they have a right to a reasonable accommodation for a disability or a reasonable accommodation for a sincerely held religious belief. An independent contractor will not have those rights because they're not covered by Title VII or the ADA. There may be other rights they have under contract or under state law. So you're going to have to look at that in each individual circumstances.
All right, the next question is about OSHA. Could you clarify about the OSHA notification? Is that only if the exposure took place at work and a hospitalization or death follows, or does that apply even if there's exposure to other employees in the workplace?
So the question that OSHA is going to be concerned about is it a workplace accident or injury? There is a presumption. I'm not the OSHA guy, and I don't play one on television, so don't throw stuff at the screen. There's a presumption that if an employee dies or comes down with COVID-19, it is a workplace exposure. I didn't make it up. It's presumed to be a workplace exposure unless you can show evidence that it's not. So if an individual dies or is hospitalized as a result of a COVID-19 infection, which you may not know about for weeks down the road, it is presumed to be a workplace exposure until you're able to prove otherwise. And you may be able to prove otherwise. There haven't been any other outbreaks. No other employees have been sick or come down with COVID. You have safety protocols in place. Those are all of the things that marshal your situation. If you have an employee that has been sick or hospitalized, I strongly urge you to get qualified legal advice quickly. If you report on occupational exposure, it will likely lead to an investigation into your workplace. That's just what OSHA does. That's their job. The inspection may be remote. It may not be a big deal, but something is going to happen down the road. So please, please, please get legal counsel as quickly as you can.
Next question, how do you handle employees that want to know who in the organization is vaccinated? It's the policy of the organization not to disclose it, but some employees are saying they feel exposed not knowing if their colleagues are unvaccinated.
Well, again, if everyone is wearing a mask, it shouldn't be a problem, right? The CDC has said that even COVID infected, asymptomatic COVID positive people can continue to work if they're essential workers, as long as they take safety precautions, frequent hand washing, social distancing, and mask wearing. So what that means to me is that if your policy is not to disclose, which I tend to favor, it's up to every individual employer to decide what they want to do. I tend to favor non-disclosure of vaccination status. Make sure you have other protocols in place for people to be safe.
Okay. Question about clients and patrons. Can you ask the clients and patrons of the organization if they are vaccinated, just like the employees?
I think you can. The fact that New York has given us permission to have vaccinated only sections, I think is a sign that New York state authorities believe it's appropriate. I think it's an interesting approach. The question is how you prove vaccination status and what records do you keep. If you're going to have a requirement that only vaccinated people come into your organization, come into your contact with your employees, how are you going to have them prove it? And are you going to keep any records of it? And think about the public relations impact of that. Particularly if you are an organization that caters to a wide range of group of people. Again, remember, kids under 12 can't get vaccinated. Some older folks are going to have medical issues that prevent them from getting vaccinated. So those are kind of the areas we need to be concerned about. And then if you're going to have them prove it, how are you going to verify the proof? There are, unfortunately, fake vaccination cards going around now. So we need to be concerned about that. Think about that, and then think about whether you're going to keep records of that information or not. I think that each individual organization has to have a group that's thinking about these things so you have a consistent approach and a consistent policy.
Thanks. We have a question now, actually we have two questions about travel, one both locally in the United States, in and out of state, and then related question internationally. Can the organizations require or mandate testing following travel and upon return to Connecticut before the employee comes back to the office? It's their understanding, this person who's asking, that it is not a CDC recommendation that testing follow international travel. So how should they handle it as the employer?
Yeah, that's a really great question. So a lot of countries will, let's talk about international travel first. A lot of countries will not let you come back to the United States without testing or go to their country without testing. So testing is pretty widely accepted at this point in time. There are no, I think some of the airlines require it too. So there are no, in the United States, there's no mandate where we had those quarantine requirements last year. Those are no longer in place in any state of which I'm aware. The question is, do you want to voluntarily adopt those policies? I think that there are good reasons to do that now that we're back in Delta. The problem for me is that I think that there's kind of a false premise behind it. Just because you go down to New Orleans, for example, Louisiana having the highest infection rate of any state in the United States right now, just because you've gone down to Louisiana doesn't mean you're being irresponsible. And just because you go to the Connecticut seashore doesn't mean you're being responsible. So again, I think part of the problem is a shorthand that's supposed to be a way to deal with these issues without having a more thoughtful, longer-term analysis of how you're going to handle the situation. I think testing could be a requirement. You need to think about that, but you raise all the same issues. Who's going to pay for the time to get tested? Who's going to pay for the test itself? It seems to me to be different if the employee is traveling for business reasons out of state versus the employee who's going out of state for personal reasons. And what do you do about weekend travel or travel during off hours? Are you going to become the off hours police organization where you require people to report? That gets back to the questionnaire issue before. You know, those questionnaires that I advise my clients to have were more robust questionnaires than just how are you feeling? It's what conduct, have you been engaged in any conduct that could lead you to believe that you maybe have been exposed to COVID-19? Did you associate with people that were known to be COVID-19 positive? Things along those lines. So I think you have to put a lot of thought into those questionnaires in order to come up with the right set of questions. And then what do you do with that information? How do you carry it on for that? It's not just a visceral reaction. It's a thoughtful process of how you deal with these situations. I think every organization should be thinking along those lines. We're kind of back where we were last year, in my opinion.
Thanks, Matt. Got another question for you about reasonable accommodation. The question is, isn't it up to the employer to determine whether or not to grant an exception or an exemption, even if it medical or religious belief? In the perspective of the employer, if there is no reasonable accommodation that could be given, is it appropriate for the employer not to grant one at all if there's a direct risk to the health or safety of the people who are going to be coming in contact with that employee?
Yeah, really, really good question. That's going to require an individualized assessment in each and every case. And the law is different by jurisdiction. So under federal law, you have to provide a reasonable accommodation for an employee to perform the essential functions of the position without an undue hardship. You cannot require the employee to perform non-essential functions. So that job description that says other duties as assigned, those other duties can never be, in my opinion, essential job functions of the position. But if it's defined as an essential job function, then you can require the employee to do it by providing a reasonable accommodation. So in a case of what about the direct threat to the employee, to the patient, for example, that may be a circumstance where there is no reasonable accommodation. But you need to thoughtfully think about that. It can't be a visceral reaction. There have been too many times where employers make this knee-jerk reaction and say, it will be difficult. The standard, it will be difficult, is not an undue burden. That's the standards. And an undue burden is a big standard. And as I said before, the New York City human rights law is a lot more aggressive and a lot more pro-employee. There is no reasonable accommodation that would present an undue hardship virtually under the New York City human rights law. So it's going to depend on your jurisdiction. If you have that circumstance, I would urge you to seek legal advice.
Thanks, Matt. Next question is, we rent our space out for private and public events. What are their responsibilities in those situations vis-a-vis COVID?
Big.
Yeah.
I mean, you're going to, particularly if you're renting out, so it's going to depend on the circumstance. If you are renting out your space like every weekend and there's a gap of a week between events where you can have it cleaned and sanitized and make sure it's safe, then I think those precautions need to be taken. If you're renting out a space like it's a laser tag facility and you get a group of kids coming in at 4 and a different group of kids coming in at 6 and a different group of kids coming in at 8, I think you're going to be under a lot more requirements to take appropriate steps to safeguard the level of public. Remember one of the first slides, we spoke about negligence liability, and that's what we're talking about with respect to liability to the public. Do you have a duty to protect them? Have you breached the duty? Is there causation? And if there is causation, what are their damages? That's the general analysis of tort liability. So when you're inviting people to come into your premises, you may owe them a bigger duty than you owe other members. Remember last year, the CDC had guidance about cleaning between events. I think we need to go back to those guidance, those guidelines, those things we were taught back in 2020 and kind of relearn those protocols. Now, I'm not advocating that it means we have to go run out and disinfect our bananas anymore. We no longer have to do that. We're reasonably safe about that, but we still have to do some of the other things. The basics of frequent hand washing, social distancing, mask wearing, disinfecting surfaces that are commonly touched. Those are really important things to keep in mind. And remember, there is going to be a public perception issue and a brand issue that comes with all of this. Are you taking the appropriate safeguards? I go to a drugstore, I won't mention the name, a pharmacy where I am, and they still are spraying down the counter after every customer. No customer touches a counter that hasn't been disinfected. That's a very reassuring message to send. It takes time, but it's a very reassuring message to send. I'm not saying that's what needs to be done. I'm saying you have to think about it from that standpoint. If you do have concerns, there are public health and industrial health experts that you can speak to that will help you figure out what's right for your organization. I'm not an industrial health expert. I can't really provide that kind of guidance.
Thanks, Matt. Another question for you about vaccine mandates. For employees who are employers who are going to be issuing vaccine mandates, how do they process the proof? Do they have to keep a copy of the vaccine status cards on file? And if so, how do they do that so as not to run afoul of HIPAA?
Yeah, great. A really good question. I do think you have to think about all of those things. Remember, whatever you decide to do, whether it's vaccinations or testing or the questionnaires, that likely, EEOC notwithstanding, that likely is all protected health information. What that means is if you're going to keep records of it, which I think makes sense, they need to be kept in a secured, limited access file cabinet or file or e-drive or something that is accessed only by those with a need to know. Usually other employees and first level supervisors are not people with a need to have access to that information. So you should have that information stored, I think, the same way you would store other health information of the employee. I think that's kind of a default position that I'm comfortable advocating. Keep it the way you would the medical records, the FMLA forms, all of that stuff. Keep it secured and make sure you safeguard it.
Okay, another question here for you. An organization that provides services to other organizations and is required pursuant to those contracts to use vaccinated staff. If that employer, though, has unvaccinated staff because that staff refuses to comply with vaccination, what is this organization supposed to do when it's dependent upon those contracts which require compliance with vaccination?
Yeah, I have not heard of a contract requiring vaccination employees only. I think that creates a challenge for the employer. I'm not sure that was a great idea. I have encountered that situation in the real estate context, and I have urged a dialogue with the agency asking for that guarantee and explaining my limited ability to provide those guarantees. Usually I have found that a dialogue about the legal limitations of disclosing vaccination status and alternatives to that usually are able to convince the requesting contract or contractee, I guess, of the need to not have that kind of a mandate. And again, I also go back, and I used it here, vaccination status is not a talisman for no risk. It's greatly reduced risk, but it does for the individual to be injured, but it doesn't mean the person can't be a carrier and can't infect others. And so I try to have a dialogue with folks. At the end of the day, I am not sure whether you can say to an employee, look, I got to let you go because this contractor requires you to be vaccinated and you're not. If they have a sincerely held religious belief or they have a medical reason not to get vaccinated, you could be on the hook for that. You could be liable for that. So I would urge you to seek legal counsel about those contracts and see what you can do to renegotiate them.
Thanks, Matt. Here's another question for you about the duty of care. Are the volunteers of an organization owed a duty of care similar to that as invitees?
Yeah, I think so. They're not employees. And so I divide the world into three categories. Employees, people that you're providing services to, whether it's performance or whether it's physical assistance or whatever it is you do. And then people that are otherwise not your employees that are helping you, whether they're volunteers or independent contractors. And I think you're going to have sort of them in the same way. Recognize that there are thousands of law books across the United States with hundreds of thousands of cases that have been litigating these issues for over 250 years. So there's a lot of law out there. You can't possibly know it all. I certainly don't claim I do. There are going to be unique variations. So when I was talking about the duty of care, I was talking broadly about that, but it's going to change on every circumstance and every individual.
And a related question for you about that with volunteers. What about organizations that want to impose mandates on their volunteers? Is that feasible? And if so, what would be your recommendations about it?
Yeah, I think, again, you have to take it on an individual circumstance. Remember, if you impose mandates on your employees, you may lose some employees. If you impose them on volunteers, you may lose some of those volunteers. So I think that's the practical matter. You can clearly do it. There's no civil rights law of which I'm aware that says someone has a protected right to be a volunteer for your organization. But having said that, think about what the impact of that mandate is going to be on your reputational brand, on your business, and how it's going to be treated in the community. We're already seeing, it's no surprise, there are a lot of dissenters from these mandates. It's become very, very political. So you need to think about how you're going to handle that situation. Now, fortunately, in New York and Connecticut, we have a lot less of those than we do in other states, but they're still here. We still have those challenges.
Here's a good one. How do you determine if a vaccination card is fake? Do you know the answer, Matt?
Yeah, I really don't. It's pretty shocking that I think, just like counterfeit bills, I think people are making a lot of money to give a card that you can get for free just by getting a shot in the arm. But I don't know how to do it.
Okay. Here's another question for you about venue activities. So an organization that secured a venue for October 2021 with the expectation that things would be better because of the vaccines coming out, now is seeing they've got Delta, they've got Lambda, more things are coming down the road. What do you think about their legal position for postponing or canceling this contract?
Yeah, you've got to, that's a question of contract, what contract you signed, whether or not you have a force majeure clause, whether or not you have the options out. That's a landmine. I know we are dealing, my former firm has a tremendous amount of litigation over breached venue contracts, marriage contracts. I know a lot of people that lost their deposits on trips and things along those lines, and they don't look like they're going to get them back. So it's an individual matter. You need to speak with legal counsel about your rights and obligations, but it's going to depend first on the contract and second on state law in most cases.
Thanks so much, Matt. Here's one more. What are your thoughts about the freedom of employers to impose vaccine mandates once the FDA grants approval to one or more vaccine?
Oh, great question. Great question. It depends on the approval, I think. I think that we're now using this emergency use authorization because we're in the middle of a public health emergency. Once the public health emergency ends, hopefully soon, I think we have to reassess all of this stuff. It's the same issues that we get when we deal with other medical certification requirements. Can you require someone to take a medical test? Can you require someone to take a fitness for duty examination? Things along those lines. So it's a whole bunch of issues, and candidly, I'm having enough trouble keeping up with the stuff that's going on right now. I have no idea what happens when the FDA gives full approval to any of these vaccines, which I do suspect is going to happen pretty soon. So it's worth another seminar, another webinar.
Matt, you have been incredibly generous with your time. I have one more question. Would you be able to take that one? And then are you comfortable wrapping up, or you want to stay online a little bit longer?
Let's do one more, but I urge you, if we haven't gotten to your question, feel free. My contact information is here. Feel free to reach out. We'll do what we can as best as we can, as soon as we can. We're all just trying to help.
Perfect, Matt. Thank you. And here is your last question for this afternoon. Is it possible to mandate a vaccine for staff premised on the fact that they are working with children who are unable to be vaccinated?
I think that is an excellent question. I think that those organizations that have that present those issues, dealing with young children, dealing with vulnerable populations, dealing with hospitals, I think they have a better argument to mandatory vaccines than the rest of employers. I'm still concerned about the mandate to take a medication. I do have concerns about that, both from an ADA accommodation standpoint and a sincerely held religious belief standpoint, but I understand it. And I do think that's an excellent argument for why vaccines may be mandated. Now, up until now, the only courts that have looked at this, there's a United States Supreme Court case from 2005 that held that mandatory vaccinations were completely appropriate in New York City for, I think it was for polio. And in the Seventh Circuit held that they denied injunctive relief to the University of Indiana students who didn't want to get vaccinated before going back to school. And as I said, one United States Supreme Court justice refused to take up that case. So I think there is a growing body of law that says you can mandate them. I think I may have mentioned, I don't believe that should be the rule, but I'm kind of giving up the ghost on that. I think the tidal wave that I see coming at me because of the COVID-19, because of Delta and Lambda and new Coke and all the stuff that we're dealing with, I think that's likely going to be the trend in the future, for the foreseeable future.
All right, Matt, thank you so much. And for those of you who we were not able to get to your questions, I think there might be a few. Please, as Matt said, direct them to him, follow up, and he'll do his best to get to them.
And I want to thank both the Pro Bono Partnership and the Hartford Foundation for Public Giving for the opportunity to talk to you today. I've really enjoyed the questions. I've really enjoyed the opportunity.
And I just want to dive in and give a big thank you to Matt and to Robin for so skillfully asking and answering a dizzying array of questions in a very changeable landscape. So thanks so much to both of you and for staying on and giving us this extra time. And thanks to everybody for being here. Look for the link following this session with the survey, as well as the recording and the slide. So thanks, everyone. Appreciate it.